My name is Wendy Manzo and I am a prophetic artist. Today I'm speaking with Kayte Lewis, the CEO of Voice Lawyers. Kayte and I have known each other a long time because our children went to school together. But she is an exceptional lawyer and she specialises in intellectual property and copyright law. So today I'd like to speak to Kayte about the finer details of what we need to know as artists. Kayte, thank you so much for being with me today.
Hi Wendy, how are you? That's you're welcome. It's great to be with you today. Even though we're not very close to each other anymore, it's amazing what we can do with Zoom and online. So yeah, thank you for having me.
You're welcome. Thank you for being here. So one of the things that comes up for me a lot when I'm mentoring artists is they want to know how much they can use from reference photos and what the copyright is on even free to use photographs. If they use more than one photo to reference, for example, the wing of an eagle or the eye or a beak of a different photo, where do they stand?
Right, Wendy, that's a really big question in terms of copyright. And there's a fair bit of background to understand before we can get to, I guess, a simple answer. And there probably is no straightforward, simple answer on that. It'll depend on a lot of different factors. So I think probably a good place to start is a little bit of an understanding of copyright and how it came about. So copyright came about in order to protect people who were artists and creators and innovators, in order to protect their rights. I think sometimes when we're coming at it from this angle of, you know, what can I get away with, or what can I use, I think it sometimes gets a little bit distorted, and we forget that it was started to protect and to add value to artists and creators. So I think that's probably a good starting point to come from. And it also flips it around a little bit in terms of the way you look at it. So when you're looking at copyright, first of all, I need to say that it's a little bit different in Australia to the US. So everything is copyright. If you've actually put pen to paper, or, you know, a photograph, or you've created some material thing, it has copyright. So, and it belongs to the person that created it unless something else has happened to it. There's a couple of exceptions though where you can use it, and one of those is for educational purposes. So there's five fairly straightforward exceptions to the copyright protection. So if it's for educational purposes, if it's for helping somebody with a disability to access the material, there's also another exception. If it's for parody or satire, that's an exception. And that's also a tricky one that you might want to talk a little bit more about later on. And if it's for research. So there's a couple of exceptions to copyright where you can use it. So obviously you're talking a lot to students who are learning about art. So that's an exception. It's a viable exception, and you can pretty much do whatever you like. The problem you'll have though...
When a student uses a piece of work, being an exception, does that mean, what does that actually mean?
So the issue that you'll have is you can use it. You can say that it's for study and for the purpose of learning, research or study. The problem you've got though is if you then have to go and exhibit that artwork.
Yes,
so
sell it. That's what people do.
And sell
the work they've made in an art class.
Exactly. So whatever you're just in class and looking at it and for your own purposes of learning, you're all fine. The problem goes when you want to have an exhibition at the end of the course and you can't exhibit it. And then obviously it would go on from there that you can't sell it. You can't commercially gain from somebody else's work. So you would need to obtain those permissions in the planning phase of your creation if you think that that's where you're going to go with that. That's a really important part of the process.
Now, while we're on this subject, can you just tell me an exhibition? Does that also mean displaying, posting on Facebook, putting out in the public domain?
Yeah, so one of the rights that you have as a copyright holder, so let's supposing that you've made an artwork and you're the copyright holder, one of the rights that you have is the right to communicate that artwork to the public, which of course now in many, many ways means the internet. So it's you taking your work to the internet, or publishing it or copying it, reproducing it. So they're the very core rights of copyright. And so, yes, so that's where you would have an issue in that you have no right to take that artwork to the public.
So I'm hearing you say that if I've been in a class and I've learned how to paint poppies after the style of the teacher, that I then cannot put that picture onto the internet without permission from the original creator.
Correct, without permission. So you need to get those permissions in place. They can be as simple or as complicated as we like. So if we're actually getting those permissions, so those permissions are usually called licenses. So it's a copyright license for a particular use. Then you can take that. And that can be for a limited period of time, or it can be for in perpetuity.
I imagine most of the artists in classes would be just going to their teacher saying, can I put this on Facebook? That wouldn't be in writing. So does that mean that they need to actually get it in writing?
Yes. It's always, I'm a lawyer, so we like everything in writing.
Right. Oh, he said I could have it. Yes. Okay.
Yeah. And look, and that it can't constitute an assignment or a license without it being in writing.
In writing. Okay. Thank you.
So, yes. So, and it could actually be as simple as something that's at the start of the course. Those sorts of things that where you agree at the beginning that that's what you're going to do with it. But there does need to be some acknowledgement that that's the arrangement that you have.
Okay, so there's a point. If it's at the beginning of the course, it could be 4 or 5 different pieces that a student produces, and it's generic, or does it have to be for each piece?
I would say as long as you identify what's within the scope of the agreement. It's like any agreement, just having to identify what's in the scope of the agreement.
Okay. Got it. Thank you.
Yeah. So, that has been an issue for some of our Year 12 HSC students in Australia, where they've done an amazing artwork, and we have the big Art Express exhibition at the end of every Year 12 graduation. And some of the amazing works that we get in Art Express, they get to go on tour around the country in an exhibition, and where either permissions weren't obtained in the planning phase, or there is no permission ever being granted, then that rules out some of those artists from participating, and they may lose their spot even though their artwork's really brilliant and would have otherwise made it. And that has been an issue for many young artists that didn't realise they needed to do that.
Yes, that's one thing I've noticed. People have said, I didn't realise, I don't think it matters. And I'm like, sorry, your opinion actually doesn't count, and neither does you not realising you can't now use this without...
That's not a defence. The only defence in Australia for copyright is that it was for research, is that it was for to help somebody access it that had a disability. You're allowed to reach for... You're allowed to have the copyright to copy or reproduce. Or so if an example of that might be if you've got a film and you're putting in subtitles so that other people can access it, or you're putting something to it, altering it in some way so that it makes it accessible for somebody with a disability, then you're allowed to copyright the work in that circumstance. or if it's for parody or satire. And that's an interesting one, because that has to be the core reason for copying the work, is for parody or satire, and not for any commercial gain. So that's where that becomes a really tricky one. So
I imagine mostly that would not apply to prophetic artists. So
probably not.
we could probably go, okay, if we need a conversation, I'll phone you back.
So while your parody and satire probably doesn't refer to your prophetic artists, there is another right that sits alongside copyright that a lot of people are very unaware of, I find, and that's the moral right that is associated with any artwork or creation. So the moral right is the artist's right to adapt or to change the piece. So supposing I even licensed something from you, and I then went on and I changed it in some way, then I could be actually infringing upon your moral rights as an artist. And that's something that is in Australia is a non-delegable right. So I can't give away my moral rights. I can't sell them. But what I can do is I can give you an agreement that you can alter, and I will waive my moral rights. So I can't actually sell my moral rights as an artist, but because they are mine. And that's where, if somebody was to take your artwork and to change it in some way. So I think that is relevant to the question that you're talking about, because if you take something and then you change it dramatically, or you do it in a different color or something like that, then you've actually impinged upon the moral rights of the artist. And that's
actually made me think of something even like a bigger question than that. Is if somebody was to take a piece of Christian art and redo it in a way that was mocking Christianity, that definitely feels like the moral rights being, what's the word? Violated.
Yeah. And that's an interesting one, and it actually hasn't been tested in the Australian courts, that one, because so that's where you would probably use a defence of parody or satire. And you would say that, you've taken something and, you've made a parody of it, as in mocking it, but it could be argued that you are actually infringing upon the moral rights of the artist. And that actually has not been tested, because they're very, very closely aligned. But it's something to be aware of.
Like our artists, it would be around the other way. They would be the ones wanting to protect their art from that happening to it.
Then you have to assert that right. And so with any of your work, you automatically have a copyright in Australia. You don't have to do anything to register a copyright. It's in
the States you do, but I don't know the laws of America.
I think in the States, I don't know that you have to register it to protect it, but there is a register.
Yes.
So which is like an extra step that you might be able to take. But you'd have to speak to an American attorney about that. But in Australia,
all the laws are different in all the different countries. So if somebody is listening and watching us today, whatever country you're in, please check for your region.
Yes, you need to check. So you might be protected. Many countries are protected by the Berne Convention, which is an international copyright convention. Not all countries are signatories, though, to that international convention. And if they're not a signatory to the Berne Convention, then your work is not protected. But if they are, then there's a reciprocal right within those countries that protects your copyright. So it is always a good idea to put the little international, copyright symbol on your work, if that's relevant, particularly printed work. You don't have to do that for it to have copyright, but it does just remind people, and it's sort of asserting that, saying, hey, I am concerned about my copyright to do that. So I think it's a good idea. It's good practice to get into.
Yeah. Well, The biggest grey area that I find artists are in confusion is when they're using photographs as reference for their work. So they're not trying to steal anything. They're just like don't know what an underwater shark looks like, and so they're looking at photographs to do a painting. So are they infringing copyright if they just use a little piece of this and a little piece of that?
I guess it depends if it's identifiable. If it's something that is substantial and significant part of the artwork, and if you can identify it. So there are certain places, so I guess this isn't exactly an answer to your question directly, but for example, the red in the Coke sign is trademarked. So that colour is not only copyright but trademarked to protect that colour. Because it's so strongly associated with Coke and has such value attached to it. So there are some things like that that you might need to be aware of. So if you take a tiny little inspiration from something, then that's not actually copying it. But if it was identifiable and you were to put together a whole bunch of pieces that you could identify, perhaps in a patchwork type of formation, then yes, that would be copyrighted if it's identifiable. And I think I read one of your articles and you mentioned about where does this 10% come from. And I think that's something that people have, particularly in Australia, have become confused with, is it's not, well, if I just change it or I only use 10% of it, then I'm okay. That's actually not correct. No. So if it's identifiable, then it's, I'd say, yes, probably you've got a copyright issue. But the 10% in the actual Copyright Act in Australia, which is the Copyright Act of 1968 that you need to go to if you're in Australia. I can't tell you if you're in any other country. I could look it up, but
not today.
not right now. So what that does is it specifies in educational purposes what fair use is. And that's where that 10% comes from, and people get quite confused. So if you're copying a book, say, or one chapter or 10% of a written work, then you're able to copy 10% of it and it's considered fair use. But that's only if it's for educational purposes. So I think when people have sort of latched onto that and extended that out, and that's actually not what the law says.
No, the Nike swoosh might only be 10% of your painting, but it's identifiable.
It's definitely identifiable. And I think you've got more than copyright there. You're definitely heading into trademark and asking for
big trouble.
Yeah. So that's.
I knew that was a myth that a lot of people get confused with. Like, I only have to change it a little bit, or if I just use this much. And I was like, But I love that you used the word identifiable, because it's like, okay, now you like, an artist knows in the heart when they've copied something, but to go, if I just want the fold of the fabric from this photograph, it's not identifiable in the whole scheme of their painting. Yeah. It's good.
So that's the key to it. And it is, like many areas of law, it is a little bit grey in terms of that. So you'll hear that particularly in relation to music and the copyright there, which is I guess a little bit different. But there'll be like a bar of music, and there's lots of cases of that where it's like, no, you've copied that, and they've actually found that they have. So and again, it comes down to the identifiable test. Is this identifiable that this is where this came from? So yeah, that's
awesome
question to ask.
You've answered both the big questions that really needed the fine detail clarified. Thank you. Is there anything else we should be aware of?
Oh my goodness! Well, there's lots of things
that you want to say today.
That's definitely a big question. But I think as long as I think the first part is to know whether you're, in terms of your students are copying it. And obviously then your students are going to want to go on and protect their own rights, which is, I guess, why I started out by saying sometimes when we look at this, it's like, oh, what am I allowed to get away with? But the broader sort of purpose behind copyright is to protect the rights of artists, so that it encourages artists and creators to create and innovate and invest their time and money and energy in that. That's what these laws actually do, and that's why there's big international conventions that protect your copyright and your artistic works, because artistic works are really important. They're really important as a basis for our economy, and if people don't create, then we don't move forward. So I think if you look at it in that way, then it does change it a little bit. And then as you go through with your own artistic work, then how do you protect that, and to be aware of that and to assert those rights at the appropriate time is really important. So there's obviously ways of doing that. So there's different things to understand, and maybe that's a topic for another day. But happy to.
Perhaps, I imagine we might have many questions come up from today's interview. I've already thought of a couple myself. I don't think we would have a problem with our artists with their integrity of wanting to get away with something. I don't think that's going to be an issue. You never know, but I don't think that's the issue. I think the issue is more of they want to do the right thing, and they've been educated that the images that they go to free to use sites, that they are able to use whatever they want. And perhaps that needs a clarification if you've got a quick answer for that.
So free to use sites are great, and there's different licenses that are available when you're talking about creative licenses, and that each of those free sites will have its own license. So it's important to understand what you can do with the license attached to that image, and they will specify it. I know, because we do this work with blogging and those sorts of things, that you have to check, well, can I use this for commercial purposes, or can I not use this for commercial purposes? Where does that stop? If I put this on my website, is that a commercial purpose? So it does get a bit more complicated. So each of those sites, and there's quite a number of them, will have in the fine print what is the license attached to these images. So it's always a good idea to have a look at that.
Have a check. The other thing I thought of is what we get told is if you just credit the original creator, that's good enough. You haven't got permission, you're just going to credit them. What do you say to that?
Sometimes that is specified in those licenses. That's part of the license. And when you are drafting a license for someone to use a creative, artwork or a logo or a piece of something creative, and you're drafting a license, what you need to do is you look at the terms of that. And sometimes how an artist is to be credited is actually specified in the license, and that constitutes part of your agreement in using that. So that could be the case. Again, it comes down to the license. So you have to be aware of that and have a really, really close look at that. It is kind of best practice to just credit people anyway. A little bit like if you do an assignment, and you're writing an essay, you have to acknowledge where you got the input from.
Yes, where did the idea come from? Reference it. Even when you've paraphrased, you reference it. Yeah.
So acknowledging and referencing is good, is part of it. But if you need to know whether or not you need to reference, or you should reference, then it will often be set out in the license. And they will sometimes have quite specific ways that they want that to be done.
So basically, when I'm talking now not about the free to use sites, but basically you've found a photograph on the internet. You must find the photographer and ask permission. It's not enough to say, photo credit Joe Blow.
No.
Permission, don't you?
You need permission. You need to track that person down. And there's lots of tools now that you can use where you do image searches and reverse searches.
Reverse
and
search.
you can go both ways, where if you've created something, you can actually search to see if someone's used your image inappropriately or without permission as well. And just like searching a key term, you can search an image on the internet and it will show all the places that that's been used. So that's something to be aware of if you're looking.
You can be found. Yeah, I have people saying, oh, but it's the internet, it's so big. So I'm like, no, you can be found.
No, it's actually not that hard. So not that I'm overly technical. I've done it 1 or 2 times, but I usually get somebody else to do it for me, but it definitely can happen. So
yes, one of the kids.
Yeah.
Okay, thank you so much for speaking with me today, Kate. I really appreciate it. I appreciate your intelligence and your wisdom, and for just those finer details that we're like, this is okay and this is not okay. I think it's important for artists to understand what they can do and what they can't do.
I think, yeah, great. And if they can just, also it helps you to go ahead with confidence as well, that you are doing the right thing.
Yeah, that to know that you are doing the right thing, that's awesome. Yeah. Thank you.
You're welcome.
Okay, one more question if you don't mind. We hear the terms fair use and fair dealing. So could you clarify, are they interchangeable? Is it just 2 different countries, or what's the story?
They're not interchangeable. So, which is something to be aware of. So fair use is an exception to copyright in the United States only, and it only applies to the United States. So fair, people often say, oh, but it was fair use. If you're in Australia, fair use doesn't apply. We actually have stricter copyright laws in Australia. So it's fair dealing. And fair dealing relates back to the few exceptions that I mentioned at the beginning of the interview, which is for education, study, research.
Yes, we're testing everyone now. Were you listening earlier?
And also for parody and satire. So they're the only exceptions in Australia. So in the US, you're going to have some broader use of your material than you would if you were in Australia.
So what I would say to our American friends is to please double check what you can do with fair use in your country. It's different to ours. Thanks. Thank you, Kate. Thank you for clarifying that final point. And I hope you'll come and talk to us again one day.
I will. Thank you.